Nnamdi bụ onye du anyị mụọ, o meriwo n'izu mbiro ya, abakarị mama ndawụra, unu abụghị meri Nnamdi. Nnamdi win the war, Python dance 1, Python dance 2, na Python dance 3, unu abụghị meri Nnamdi. Nnamdi win the war, Python dance 1, Python dance 2, na Python dance 3, unu abụghị meri Nnamdi. Nnamdi win the war.
Bless you. Let's continue. The import of the above constitutional provisions, in so far as the petition is concerned, is that they fully applied to Mr. Nnamdi Kanu to the full extent as soon as he entered and remained within the territory of Kenya, whether lawfully or not. He was to enjoy his rights and fundamental freedoms and was to be treated fairly and justly as required by the Constitution and the law. If, for any reason, he was to be arrested, the arrest had to be lawful. Those arresting him had a constitutional duty to inform him the reason for the arrest and had to produce him in a court of law in Kenya within 24 hours following the arrest. Article 51(1) states in plain language that a person who is detained, held in custody or imprisoned under the law retains all the rights and fundamental freedom in the Bill of Rights, except to the extent that any particular right or fundamental freedom is clearly inconsistent with the fact that the person is detained, held in custody or imprisoned. Article 51(1) contemplates only situation where the person has been subjected to due process and is being held lawfully, and even then, the person retains all his rights, except those that he may not enjoy by reason only of being in lawful custody. In the case of Mr. Nnamdi Kanu, the averments in the petition and the positions in the affidavit show that he was abducted without warrant, detained, tortured, and later taken out of the country without any court order to that effect. The respondents admitted that there was no record in any police station that Mr. Nnamdi Kanu had been lawfully arrested. They also admitted that there was no deportation order issued by a court in Kenya. They did not argue that there was a warrant or order issued by any other court outside Kenya, or even a request from any country to surrender or extradite Mr. Nnamdi Kanu from Kenya. That being the case, no one had constitutional or legal mandate and power to arrest Mr. Nnamdi Kanu within the territory of Kenya, except those authorized by the laws of Kenya, namely officers from the National Police Service. Even then, they had to do so in compliance with the constitutional standards of human rights and fundamental freedoms, as required by Article 244C of the Constitution. The government of Kenya, through the respondent, did not show that there was reason for Mr. Nnamdi Kanu's arrest in Kenya. And if there was such reason, it was to be accorded due process and was not to be treated in a manner that violated his rights and fundamental freedom, since Article 22 of our Constitution recognizes rights of every person, so long as the person is within the territory of Kenya and abides by the law or laws of Kenya, regardless of his citizenship. This position was reiterated in Moses Tengenya Umweno via Attorney General 2018 EKLR, that one is entitled to due process irrespective of his citizenship. Article 12(1) of the African Charter on Human and People's Rights also provides that every individual shall have the right to freedom of movement and residence within the borders of a state, provided he abides by the law. In that respect, Mr. Nnamdi Kanu had the right to reside in and move around Kenya for the period he was in the country, as long as he did not break the law. When the Constitution speaks, it does so not as mere suggestions, but commands whose compliance is without questions. The Court of Appeal affirmed this position in Attorney General and two others v. Kituo Sharia. Rights have inherent value and utility, and their recognition, protection, and preservation is not an emanation of state largesse, because they are not granted, nor are they grantable by the state. The court emphasized that under Article 20, the Bill of Rights, sorry, that one was loading up, so let's go to this 67. It said the Constitution enjoin every person to act lawfully insofar as rights and fundamental freedoms are concerned, bearing in mind the theme of maximization and expansion in matters enjoyment of rights and fundamental freedom. The fact of this petition, and more so the way Mr. Nnamdi Kanu was treated, point to a clear pattern of violation of the Constitution and the law right from the time he was abducted, held incommunicado and forcibly removed from the territory of Kenya. The government of Kenya owed Mr. Nnamdi Kanu a duty to respect and protect his rights and fundamental freedoms, including his personal security guaranteed by Article 29 of the Constitution. If he was to be arrested, there had to be justifiable cause for doing so. And even then, he was to be subjected to due process. Those involved were required to act within the tenet of the rule of law and human rights, foundational values in our Constitution. The rule of law requires that all public power be sourced in law, which means that state actors should exercise power within the formal bounds of the law. The abduction of Mr. Nnamdi Kanu, the way it was done without due process, is incommunicado confinement while in chains, his treatment, including being denied basic necessities such as food and water, denying him access to medication despite request, were acts that are outlawed by the Constitution of Kenya 2010. In that regard, I find and hold that there was gross violation of Mr. Nnamdi Kanu's rights and fundamental freedom. When the judge will be like, this is my judgment. This is the part now. So they said this brings us to the issue of who should be held liable for the violations. The actions that led to the violation of Mr. Nnamdi Kanu's rights and fundamental freedoms were committed within the territory of Kenya, the country that had the duty to respect, uphold, and protect his fundamental rights and freedoms. The respondents denied knowledge of Mr. Nnamdi Kanu's abduction, his incommunicado confinement, torture, and eventual forcible removal from the territory of Kenya. They maintained that the government of Kenya was not aware and was not involved. If the respondents' assertion were to be believed, it would only show how perilous we stand as a country. That foreign agents can enter the country, conduct clandestine operations, abduct people who are lawfully in the country, hold them incommunicado, torture them, and take them out of the country through some of the most secure national installations without the knowledge of the government and those responsible for the security of the country. It is implausible that Mr. Nnamdi Kanu could have been abducted in broad daylight, held incommunicado in Kenya for 8 days, put on a plane at JKIA, and taken out of the country without the knowledge of the government and those in charge of the security of the country, including the airport. This court cannot accept that such acts could take place in an independent and democratic state governed by the rule without the knowledge of those in government. It is my finding, and I so hold, that the covert operation to abduct and forcibly remove Mr. Nnamdi Kanu from the territory of Kenya was done with the knowledge, connivance, complicity, and tacit approval of not only the government of Kenya, but also those in charge of the security of the country. The operation haven't been executed without any attempt to comply with the Constitution and the laws of Kenya. The government of Kenya failed to respect, uphold, and defend the Constitution of the law. Instead, it allowed violation of Mr. Nnamdi Kanu's rights and fundamental freedoms in breach of fundamental values of the rule of law, human rights, and accountability for which the government must be held liable. So here is the court relief, meaning since it has been established now that Kenya was involved, the violation, the torture, the abduction, and every other thing of Mazi Nnamdi Kanu in the last, for 8 days in Kenya, so they are guilty. Appropriate relief, as your lordship pleases. You all say that when I finish reading, okay, you say as your lordship pleases. Having determined that Mr. Nnamdi Kanu's rights and fundamental freedoms were grossly violated, the next issue is what relief should the court grant? This petition was brought seeking redress for the violation of Mr. Nnamdi Kanu's rights and fundamental freedoms enshrined in the Bill of Rights, with the belief that this court, as the protector of the Constitution and the fundamental values embedded in it, namely the rule of law, fundamental justice, and preservation of the democratic process, will respond and redress the violations. Article 23(3) of the Constitution vests on this court jurisdiction to grant appropriate reliefs, to redress violations of the rights in the Bill of Rights. The essence of such relief must be to ensure that the rights enshrined in the Constitution are protected and enforced. First v. Ministers of Safety and Security, 1997. Once the court finds that rights and fundamental freedom have been violated, it has an obligation to grant an appropriate relief as required by Article 23(3) of the Constitution. In cases of violation of the Constitution and fundamental freedoms, the court must consider whether an award damages as compensation towards the violation is the appropriate remedy. The state may be required to pay damages for making decisions that are plainly unconstitutional, are in bad faith, or an abuse of power. The petitioner has demonstrated that indeed Mr. Nnamdi Kanu's constitutional rights and freedoms were violated by the same states that is enjoined by the Constitution to respect, protect, and preserve those rights. The Tinyefuze v. Attorney General of Uganda, Constitutional Petition number 1 of 1996 to 1997, the Constitutional Court of Uganda stated that if a petitioner succeeds in establishing breach of a fundamental right, he is entitled to the relief in exercise of constitutional jurisdiction as a matter of course. In Canada, Attorney General v. Power 2024 SCC, Wagner CJ stated that Section 24(1) of the Charter, equivalent to our Article 23(3)(e), provides a personal remedy that is specific to the violation of an applicant's rights, a unique public law remedy against the state that should not be assimilated to the principles of private laws, remedies. Now, an award of damages as remedy against the state for exceeding its legal power has long been recognized as an important requirement of, so they explain to people where they want bill now. So before they tell them what the relief will be, right? So the court is letting the Kenyan authority know that, listen, all over the world, what you just did, right? If it was an individual, you go do jail. But that's fine. But you have to compensate in the form of damages. It will never make up for what they did to Nnamdi Kanu. But the fact that right before their own very faces there, they are now seeing, that it is not just so many of us who have looked into all of this that believes that the injustice the persecution of Mazi Nnamdi Kanu, right, would require reparation at a point. It's not something that should be swept under the carpet. So this is to go into the record as well. Now here, the court says, or ruled, in determining whether damages are an appropriate and just remedy, the court has to consider whether a constitutional right has been breached, whether damages would fulfill one or more of the related functions of compensation, that is, vindicating the right or deterring future breaches, and whether there is alternative remedy that would be effective than an award of damages and the appropriate quantum of damages. In this petition, rights and fundamental freedom have been violated. It was not demonstrated that there will be another effective remedy than an award of damages, quantum. The petitioner sought damages for the violations. Mr. Nnamdi Kanu was abducted on 19th of June 2021, held incommunicado, tortured, and subjected to inhuman and degrading conditions for 8 days in violation of the Constitution and the law before he was taken out of the country again without following the law. He is entitled to damages. When considering the level of damages to award, the courts should pay attention to the words of Patterson J. in Fuller v. AG of Jamaica, Civil Appeal 91 to 95, unreported, that where an award of monetary compensation is appropriate, the crucial question must be, what is a reasonable amount in the circumstances of the particular case? The infringement should be viewed in its true perspective as an infringement of the sacrosanct fundamental rights and freedom of the individual and a breach of the supreme law of the land by the state itself. But that does not mean that the infringement should be blown out of all proportion to reality, nor does it mean that it should be trivialized. What his lordship Patterson J.A. Patterson meant was that compensation should be commensurate with the violation, since once rights are violated, they cannot be restored. Any compensation is merely of palliative value. So he went on to say more about the, So now I'm gonna, let's see what they have here. No, they're still comparing. So let's go to page 60, 87. Taking these awards into account, the nature of violation herein and considering circumstances under which the violations occurred, I considered an award of Kenyan shillings of 10 million fair and reasonable. So this is where the judge ruled that 10 million Kenyan shillings should be paid in damages to Mazi Nnamdi Kanu. Now, that is an approximately 120 million naira damages. So conclusion, having considered the pleadings and arguments by parties, the decision relied on the Constitution and the law, I come to the following conclusions. First, the government of Kenya violated the Constitution and Mr. Nnamdi Kanu's rights and fundamental freedoms. Having entered Kenya lawfully, it was subject to the protection offered by the Constitution of Kenya 2010, and the government of Kenya had an obligation to uphold and protect its rights and fundamental freedoms. Mr. Nnamdi Kanu was, however, abducted, kept in solitude, confinement, tortured, and denied food and medication, a breach of basic rights. He was chained, humiliated, ridiculed, and held in contempt, and later forcibly removed from Kenya without following the law, in violation of his rights and fundamental freedoms, for which the government of Kenya is liable. So the poster, based on the above conclusions, the court makes the following declarations and orders it considers appropriate. 1, A declaration is hereby issued that the abduction of Mr. Nwaneka Envy Nnamdi Kenny Oku Kanu, holding him in incommunicado confinement, torturing him, and denying him food, water, medication, and other basic necessities was a violation of his rights and fundamental freedoms. 2. A declaration is hereby issued that the abduction and subsequent forcible removal of Mr. Nwaneka Envy Nnamdi